Now back to the show. This is The Law Show on CL 650.
Hey, and welcome back to The Law Show on CL 650. We're speaking with Gordon Maynard and Alex Stojkovic from MKS Law in downtown Vancouver. You've just moved. What's your new address again?
Suite 900, 688 West Hastings.
Voted one of the top 5 boutique immigration law firms in the country. Good to have you guys here. Now, before the break, we talked about when someone comes into the country and you're sort of in this no man's land and you have status in Canada, but they have the ability to, if you say too much, to say or threaten that you could be forced out of the country. Has no one challenged this through legal channels in Canada to go to the Supreme Court and get a final ruling on it?
Well, they have to some extent in the customs context. In the customs context, because customs enforcement has traditionally been done through the provincial court system, people have raised the case of R.V. White. R.V. White's a Supreme Court of Canada case where a woman was involved in a hit and run. Mm-hmm. After the hit and run, she leaves the scene of the accident, but later that afternoon phones ICBC and makes a full report, as she's required to do under the Motor Vehicle Act, about what happened in the accident. Later, the police arrive at her house, interview her about her statement that she gave to ICBC, ask her a bunch more questions, and then arrest her for the hit and run.
A criminal offense.
A criminal offense. There was a charter challenge that went all the way to the Supreme Court of Canada on the grounds that, look, she gave a statement that was a compelled statement under a statute. The basis of that statement can't then be used to allow essentially a constructive type of detention later, which is what the court ruled that the later interview with the police in fact was, because the police made it sound like she had to speak to them. Mm-hmm. And
as we know, you don't have to. All you have to do is give your basic information.
That's right. And then, so all of the fruit of that poison tree, if you will, could not be used in a criminal context. Because if you have a situation where you have to provide a compelled statement, it can't be used for a collateral purpose to attack you in some other context. Mm-hmm. And this is how the Supreme Court of Canada has handled this generally. And what we would argue at the border is that in the border, you're effectively in a similar situation. You're compelled to answer certain questions. And if you're past the point where they've established your right of entry and you're still being asked questions and the door's closed and they threaten you with arrest and you can't leave, I would argue that that's a constructive detention. And at that point, you have the same rights to counsel and everything else. And there's no dispute that once they actually arrest you, you have a right to remain silent and you have a right to counsel, etc. But in those circumstances between those two times, after they've told you that there's a suspicion and they're telling you have to keep answering questions and they won't let you leave, that sounds like detention to me. Mm-hmm. So I would argue that all of these compelled statements contextually are a problem. The difficulty is, though, is that once the cat's out of the bag and these statements have been put forward, you're now requiring a client to argue to take all this information away. And, with the information available, no one has successfully, that I'm aware of, had an appeal transcript taken, shut down because this was an illegal questioning.
It's a really complicated area.
It sounds it.
And it's not just complicated by the law, which on one hand says you have an obligation to answer all questions honestly for the purpose of the examination. It's very vague on what the purpose of the examination is. And you're asking a judge to draw a line and say you crossed a line. But on top of that, our constitutional law is different from the U.S. law. In the U.S. law, if there's a breach of your constitutional rights, then everything that's gleaned from that is fruit from a poison tree, and they can discard it. And not allow the authorities to rely upon it. Whereas in Canada, you have to demonstrate that relying on that evidence is going to bring the administration of justice into disrepute. And so there's a threshold to jump over before the court will say, no, you can't use that evidence. On top of that, we have to go through layers of hearings before you can even possibly get to the Supreme Court of Canada. Right. You have to go, if you're a permanent resident, where this is really going to be an issue, you have to go through the appeal division, then which is an administrative tribunal. You have to go through federal court, but only with leave of the court. You have to pass that hearing after you get leave. Only if there is a certified question of general importance do you get to go to the federal court appeal. And then, if you get leave, you can go to the Supreme Court of Canada. So nobody's gone down that path.
So it sounds to me like there's all of these layers that just lets the
government
border do really what they want, right?
Unfortunately, yes.
Yeah.
And so on a 30,000 foot level, what are the border options that you have when you come to the border?
The real question is, what are the options that CBSA has when you come
because
to the
they're
border?
the ones that hold all the keys.
You're
right?
the one making the application.
Yeah.
They're the one making the decision.
Yeah.
Basically, there's 4 things they can do. One of them is they can agree with everything you're saying and they can admit you. You say you're there to work, they can give you the work permit that you need. You say you're there for a visit, they let you come in, they give you the time that you need. So that's the best one, of course. You're admitted. Secondly, they can say, we're not sure. They can delay. And so you can get a request that either you go back to the States, if you're coming here from the States, go back and come back in 5 days.
Right.
We're going to do some look-see into this. Okay? Or they can admit you into Canada. They can ask you to return to the port of entry to continue your examination in 3 or 4 days. So they can admit you under conditions for that purpose.
Can they withhold your passport while you're doing that?
Yes, they can.
And more often than not, they do.
Yeah, absolutely. Because otherwise, you may abscond. So they're allowed to hold your passport to ensure that you comply with the law, which is to return to the port of entry to continue your examination. They can deny your application. And there are different levels of denial. One of the best levels of denial is being allowed to withdraw your application.
That's the one I see on the border security show, where you say, well, if you just decline the fact you even tried, you can turn around and go back.
Exactly.
Right.
We're voluntarily letting you withdraw your application.
Right.
Enter.
That's right. And that's a good resolution.
Yeah.
Because you're being told, look, we're not satisfied.
And there's no paperwork for them either, right?
Well, no, it's better than that. I mean, because the alternative is to proceed with enforcement. And they don't want to proceed with enforcement in every case. They want to say, look, you just don't have your ducks in order. Withdraw your application, come back again, live to fight another day. Okay? Go get your ducks in order and come back. And that's a great resolution. Right.
Now, the border doesn't have unlimited authority to issue removal orders. They can issue certain types of removal order, like an exclusion order, which bars you from Canada for a certain period of time.
Well, the one I see also on the border security is if you have a criminal offense in the U.S., for example, that would preclude them from coming into Canada.
Right.
Criminal inadmissibility.
Yeah.
Very big net.
Very big net.
Catches a lot of fish.
But in that context, depending on what the offense is, you can be reported to an admissibility hearing to determine that you're inadmissible. Okay? Or if they're aware of a Canadian offense, they can simply issue an order to you because you've been convicted of a Canadian offense already. So there's some nuance there in terms of what they can do and what they have to send things to a tribunal for afterwards. The downside, though, is if they report you for inadmissibility and it's something that a tribunal has to deal with, it's a lot more paperwork for them because they need to create a report. That report has to be sustained by a more senior officer who's referred to as a minister's delegate. That has to then be referred to the Immigration and Refugee Board for an admissibility hearing. And in between, you're typically detained.
Well, it doesn't sound like it's quick.
And no, it's not quick.
No, but there's other circumstances, though, where the CBSA officers have been given authority to be police, judge, and jury. Where they do have the authority to issue the removal order. And so in circumstances where a foreign national comes to the border and it's clear that they're there to seek employment, or it's clear that they're from a country requiring a visa and they don't have it, they can be given a removal order straight away.
So it's a little more cut and dry.
Yep.
Yes.
It was intended to cover those cases that, it made sense to give the border officers the authority, because it would have been a waste of time and money to put the whole thing through a hearing. So where that line is drawn is incredibly important.
Now, the one thing I really like, a couple of things I like about this border security TV show, pulling the curtain back on what actually happens at the border, and I'm sure it's filtered at some level. But
it is.
The one thing I think is interesting is when you see people coming across the border and they're rifling through their cell phone and they're opening their laptop, and I mean, a police officer pulling you over on the side of the street, in your car wouldn't be allowed to go through your cell phone. They don't say, hey, give me your phone, I want to go through it. That's not allowed, but they're allowed to do that at the border.
Well, that's a great question.
It's a great question.
The border finds that going through cell phones and going through computers can be incredibly fruitful.
Mm-hmm.
They can gather lots of information, for instance, to indicate that an individual who has come down to the border from Vancouver to pass on through again and get their work permit has already been working illegally in Canada, for instance. They can find information.
Oh, so that's somebody who's going back to the border after they've already cleared the border to get their work permit, and at that point they can be detained, go through their cell phone and find out that they're due for work the next day.
Every entry is an entry. It's a fresh entry. So if you leave and come back, it doesn't matter that you were here before.
Ah.
Yeah.
So just going to the border, you've actually crossed.
No, you actually go to the United States.
And then turn around and come back. Ah.
We call that flag polling. That's a very common thing in Lower Mainland.
And the border has jurisdiction to issue work permits, for instance, or study permits in certain cases. And so that's why people flag pole and come back to the border to make their application for a work permit. But in the process, they take down their phone or their computer, and sometimes an officer is interested in that, and they start going through your phone. And they have some very sophisticated software to get into phones and to do searches, and they're looking not only for illicit pornography, for instance, but for communications that tell them more about your purpose of entry and what you've been doing up here in the meantime.
So if a guy's been roofing a roofing job for the last 2 months, but he hadn't really got his permit yet,
there's an issue.
Yeah, his chances don't look good.
In 2010, the BC Civil Liberties Association did an access request to CBSA to get all of their materials about what they believed their guidelines were and their rights to search cell phones and computers and whatnot. It was very interesting. CBSA was not sure how far their rights extended. For instance, say your cell phone is locked or your computer is locked.
Are you compelled to unlock it for them?
Yes. Are you compelled to unlock it for them? It's a good question. It's a good question. It hasn't been determined. All right.
Now, if
and still hasn't been determined.
If you don't unlock it, though, you very well maybe find yourself barred entry because they're going to say we can't determine the purpose of your entry to Canada without access to this information. That's how they get around a lot of this stuff.
Or you're going to find yourself turned upside down and shaken.
Often quite literally.
Because you apparently are trying to hide something.
So, I mean, the challenge is that is the statute that gives them the authority to do this is broadly worded to allow them to investigate almost anything within the parameters of determining the purpose of your entry into Canada.
But if you had it the other way, they couldn't work because they would be handcuffed. They wouldn't be able to operate and move.
So that's the challenge.
Yeah.
And there is a line there. And I think certainly there's no dispute that they're not allowed to go through your cell phone just willy-nilly in the sense that there's no tie to what they're concerned about. There has to be some causal connection between what they're worried about you doing and
okay, I'll give you an example. I want to pick up this when we come back, because I'll give you a scenario, and I'll see what you think about would they be allowed to look through my cell phone on my laptop. When we come back, we're talking about immigration and the border on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.